say that the session is being recorded. There you have it. Second thing, if you could keep your mics muted during the presentation, if you've got any questions, pass them on to me. I'll be moderating the session, and I will then be able to pass the questions on to Louie. And those are the logistical matters. Now, I'd like to welcome Louie Azzolini as well, Doug Rankin and Mike Vaydik from the Surface Rights Board. Louie is the chair of the Surface Rights Board, and he's going to be the primary presenter, although Mike may jump in as well and interject from time to time. Louie's a lifelong Northern resident, having lived in the Northwest Territories for 50 years. He has extensive experience in community development, planning, environmental, and socioeconomic issues. He's managed the environmental assessments of 4 diamond mines, several gold and base metal projects, and has worked effectively in diverse levels of Northern governments, boards and agencies, and private sector companies. Most recently, Louie retired as the Economic Development Manager for Parsons, who is the prime contractor for the main construction management services project on the Giant Mine Remediation Project. Louie has a master's degree in urban and regional planning from UBC, a master's degree in business administration from Athabasca, and a diploma in urban and regional planning from NAIT. Louie is a registered professional planner in good standing with the Canadian Institute of Planners and the Alberta Professional Planners Institute. Most recently, he served in the Plichon Dispute Resolution Administrator and is a member of the City of Yellowknife Board of Revision and the Territorial Assessment Appeal Tribunal. Louie was appointed to the Surface Rights Board of Northwest Territories in 2015 and is currently serving his second term. And as I've mentioned, he is the chair. So Louie, without more, I will pass it over to you.
Thank you very much for that very kind introduction. And I'd like to welcome everyone that is taking time from their day to spend an hour listening to me and hopefully Mike about the Surface Rights Board. Mike Vaydik is also a lifelong Northerner, and he is the vice chair. Doug Rankin is our executive director. I like questions, so I'm not going to spend a lot of time on the front end, and I'm just going to dive right in here. The NWT Surface Rights Board. Interesting animal. I'm hoping that by the end of this presentation, you'll have more questions than answers, because we certainly do. A quick overview of who we are as a board. We are a quasi-judicial tribunal, and yes, we're an institution of public government. One difference that we have from all other boards in the Northwest Territories is that our decisions are not reviewable or appealable to any minister of government. The primary purpose of the board is to resolve disputes regarding access to land in the Northwest Territories and water overlying those lands in the Mackenzie Valley. That's a wordy way of saying it applies to everything except for waters in the Inuvialuit settlement area. The outputs of our work are orders, and those orders set out terms and conditions of access to land and the use of that land and compensation to be paid for that access. Historically, access in the Northwest Territories to land has been contentious, less so with the development of self-government and land claim agreements, but it is something that continues to be an issue and will be an issue as long as there are overlapping interests. As I said, the jurisdiction encompasses the entire NWT, both settled and unsettled claim areas, and it includes private, commissioner's land, and crown lands. That's a nice, polite way of saying that it includes municipal land as well. The Surface Rights Board is delegated the exclusive and final authority to be the final arbitrator in the event of a dispute. Certainly, there is appeal provisions, but those provisions are to the court, and they have to be based on fact and law, and you folks would know way more about that than I would. Interestingly enough, also the difference between this board and other boards is that only directly affected parties can participate. There are no interveners. You're either a party or you're not. The process is public, and we maintain a public registry in the event of an application coming before us. What enables the Surface Rights Board to do its job is the act that was passed in 2014 as the government of the Northwest Territories and Canada were negotiating the transfer of substantive responsibilities for the management of land to the GNWT. The board came into full force and effect on April 1st, 2016. There are 5 regular members and 5 alternate members, and there's a reason for alternates, and I'll speak to that shortly. Whenever there is an application before the Surface Rights Board, one member has to be from the area of the dispute. So whether that's Gwich'in, Inuvialuit, Sawtooth, Tlicho. In the non-settled areas, that's a good question. Maybe one for the courts. The board composition, myself, Danny Bea from the Sawtooth, a Gwich'in nominee is hopefully in the pipe. Mr. Tyson Perchi from the Inuvialuit settlement region, and Mr. Mike Vaydik. He's a non-regional member, and he is the vice chair. Mr. Ian McRae is a Tlicho nominee. Mr. Harvey Pierrot is from the Sawtooth. Again, we have another alternate member vacant, in this case from the Gwich'in, and you'll notice that there's a bit of a hole here in the Gwich'in settlement area, and a vacant Inuvialuit alternate member. Robert Tanash is our second non-regional member. All members are appointed for a 5-year term, and the most you can serve is 2 terms. As a board made up of bureaucrats and consultants, the first thing we did, of course, was prepare a strategic plan, and wisely so. I don't want to make too much light of that. The strategic plan establishes our mission and our vision, and this is communicated to the minister, to the government of the Northwest Territories, and it is a public document. We want to fairly resolve disputes about access to land and the water overlying those lands. And we want to do it in a way that's respected and trusted so that we can resolve land and water disputes in a fair and timely way. They're very good motherhood statements. And as always, it's always in the doing that we find out where the substance is. Our values are fairness, respect, integrity, timeliness, and professionalism. I'll let you read the slide once you get the slide deck on these. I won't go into too much detail on these. The Surface Rights Board deals with surface and overlapping surface and subsurface rights issues. It doesn't deal with air rights. That's the crux of it. There are surface rights holders which may or may not have legal title to a particular piece of land or water which is in dispute, while the subsurface rights holders are clearly demarked. The reason I bring this to your attention is because if an Indigenous person or non-Indigenous person says that a particular development will affect their body of surface rights, they may be considered a party. With respect to how we operate ourselves, we have a pretty modest budget in the low 300s, and that covers everything from rent to travel. Mr. Doug Rankin, he's our permanent half-time executive director. Our legal counsel is Dr. Larry Reynolds, and he also serves as legal counsel for the Nunavut Surface Rights Tribunal. We prepare a strategic plan based on a 5-year contribution agreement, and our current strategic plan has a 2-year budgeting and activity window. Since the board came into full effect on 2/16, we've developed bylaws which govern how we govern ourselves, rules of procedure which govern how disputes are managed and undertaken, developed application forms so that any individual that wants to submit an application actually has a form to do so with, process flow charts, question and answers, and members only guides. We've done a substantive amount of work in the first 5 years to lay the foundational elements so that in the event of an application, the members at that time will have a framework with which to operate in. Legally, the bylaws and the rules of procedure are outlined in the Act. Governments manage land. Let me just back up here. Land does not come without restrictions. People are fettered in how they can use land, and there's legislation and common law relating to real property. There's land use planning, land and water boards, environmental impact review board, and so on. The point I'm trying to make here is that this board does not stand alone in isolation. The use of land and the access to land has many parties in the Act, and ideally, this board serves as a backstop to facilitate those parties achieving resolution without having to come to the Surface Rights Board. And as I sort of set out in the beginning, the surface and subsurface interests can exist simultaneously. And while they exist simultaneously, there's also a room there for disputes. If the subsurface holder wants to access that subsurface right over the surface of the land. And any interest holder, and this is an important term, any interest holder can ask the Surface Rights Board to resolve a dispute by submitting an initial application form to the Surface Rights Board. Once the board accepts an application as complete and within the bounds of its jurisdiction to operate, the Surface Rights Board then has the legal room to issue an order. And the order set out the terms and conditions, and this means any terms and conditions on which an individual or entity can access land and waters that are in dispute, and the compensation to be paid in respect to that access. So jurisdiction does not happen automatically. There's a framework with which applications are made. Once we are triggered as a board, it takes one applicant, one party to a dispute to initiate the application process. It takes two parties having demonstrated that they've attempted to negotiate in good faith to enable the process to proceed. There are other conditions as well. So applications that can trigger the Surface Rights Board jurisdictional test, and I've just spoken to a couple of elements of it. One, an initial application. Okay, there's an initial application. That application, once completed by way of an order, can be reviewed or amended on another application by the parties or a party. We can also receive applications to terminate orders. And interestingly, and this is a nuance which took a while to sink in, there is an opportunity for additional compensation. Again, an application would have to be submitted, and it would be contemplated by the board if it met the necessary triggers. If it did, then an order would eventually be issued with respect to additional compensation. Last resort. We as a board don't envision having many, if any, applications. By historical comparison, none of it has had none. And I believe the Yukon has had 2. And in saying that, the lack of work or the lack of applications is not viewed as a failure of the board. Rather, it's viewed as a success of the board as acting as a final place of rest, if you want to call it, and as a way of facilitating, encouraging the parties to a dispute to resolve that dispute themselves. On non-Clecho lands, and just want to come back to this, the applicant has to demonstrate that they have in good faith attempted to resolve the matter. So there has to be demonstrated, if you want to call it consultation, if you're dealing with Indigenous people, and good faith discussions along with that, discussion/negotiations. We've also got a slew of other application types, and these were all set out in the legislation as well. So, and as one goes through the SRB process, issues can come up that need attention. And these are done by way of, this is legal talk, interlocutory applications. I take those to be as sort of a recess to let's figure out how we're going to proceed. There's general applications, application for costs, applications for the enforcement of an order, application for failure to comply with rules of procedure, insufficient negotiation and mediation, and substitutional service. We have, I believe, 10. You'll have to, Mike, anyone jump in here. I think we have about 10 application forms, 10 or 11. Now we're getting into the meat of what orders constitute, not the process whereby jurisdiction is determined or the procedure by which ultimate orders are derived. The terms and conditions included in orders can contain directions regarding the times when the access can be exercised, when the party has to give notice, the location in which the right of access can be exercised. For example, where is that road going to be? Speaking of routes of access, and the number of individuals who can exercise that right of access. Now, I'll just carry on here in terms of terms and conditions. We can, as a board, in our orders, include requirements regarding activities that can be carried out and the equipment that can be used, abandonment and restoration work, the right of inspection by landowners or occupier or otherwise, whether the terms and conditions of the access order and any applicable conditions established by an agreement have been complied with, and any other terms and condition the board considers appropriate to minimize any damage to land or interference with use and peaceful enjoyment of the land. The board is only interested in the rights and the balancing of those rights. Compensation. We spent a couple of sessions, professional development sessions, discussing compensation. The board must determine the amount of compensation, and in doing so, has to consider relevant factors. The including suggests that any other factor beyond those that you see on your screen can be included based on the process and the information flowing from the hearings and the evidence submitted by the parties. So what factors can be considered? Market value, loss of the use of land, effect of wildlife harvesting, damage to the land, nuisance, cultural attachment, peculiar or special value, any other adverse effect, and any reasonable expenses that might be incurred for the purposes of inspection. Then inevitably the question comes up, what happens if something happens unexpectedly? As often happens, well, the Act has considered that potential outcome, and it provides that an application can be made by any owner or occupant of land for any damage that was unforeseen at the time of the original access order. So there you have it, an individual who is an owner or occupant can make an application for unforeseen damage. If one follows that thread back to project development, project scope, licensing, you'll see that there are a number of steps there that precede an unforeseen damage application. In total, the board has received 0 applications, 1 expression of interest, and we've had board new members come on to the board this 2 years ago, year and a half ago. And so as a board, we first laid the foundational elements for the board's functioning. And now we're in a process of developing and nurturing interested individuals that want to participate, not in applications, but within the board itself, because as you've seen, we do have some vacancies. Now, I can get into the whole start of the second presentation on award of costs. And that's really a timing question. So I can stop here and seek direction.
Well, Louie, we're only not quite half an hour in, so I'd suggest that you continue on.
Okay. Okay. Now, keeping in mind that this whole awarding of costs it's a rough presentation, so bear with me. The board can award costs to applicants before it issues an order. That is, if a surface and subsurface rights holders are in lawful dispute, the Surface Rights Board does have the authority to have an advanced awarding of some cost so that the parties can proceed through the process fairly. In terms of the purposes of the Essa, of the Surface Rights Board, and forgive the overlap here, I'll clean that up before I send it to you. The land claims have different language, not all of them the same. For example, in the Tlicho, there's part 6 of the Tlicho agreement, which deals with dispute resolution. The same holds true with the Inuvialuit and Gwich'in and Sawtoo land claims, except their language is different and they don't have a dedicated chapter to disputes. And that's the key difference here. There's elements within the land claims themselves which flow through to the Surface Rights Board, and untangling those it's not a work in progress. It's not something that has even begun. And from a pragmatic standpoint, it's not necessarily something that can be done because it'll always come down to the specifics. And I don't think that there would be enough time and money to look at all the combinations and permutations. And just coming back to the purpose, this is a regurgitation of the initial part of the presentation because we are dealing with the cost presentation in this particular section. Again, the jurisdiction, it plays a uniquely distinct role from other institutions of public government because it's been delegated the exclusive and final authority to be the arbitrator on those issues. And the jurisdiction really is set out in 8.2 of the Act. So to do our job, we're given a set of tools, and those tools, we've created some of them by way of the rules of procedure, which were gazetted, so they have gone through that legal process. And this is where I want to come back to this particular point, minimizing damages and enjoyment of land. The balance that the board strives for is minimizing surface impacts or surface outcomes by way of the subsurface rights holders' effect on the surface. And we don't evaluate impacts on the environment. We don't evaluate route options and their significance. This board strictly looks at the rights of both parties with an eye to minimizing surface rights impacts so that the surface rights party can continue to enjoy their surface lands. And where there is a residual impact, if you want to call it, that residual is compensated for financially. And rather than me going on, because of the roughness of the second one, what I would prefer to do is stop here, invite first Mike or Doug to correct me or castigate me, and then open this up for discussion, because I find being able to interact with individuals, with groups, as a really positive way to both inform oneself but also learn, and that goes both ways. Mike, Doug?
I'll just jump in with a few words about the first part of the presentation. One of the things I think we're quite proud of is that we have published a set of flowcharts which tries to explain in great detail our rules of procedure, so that if someone has an application and they want to know how to make an application, who it goes to, what might happen to that application, and we've attempted to explain it in some detail, in fact, great detail, in a set of flowcharts that we've developed over a couple of years, actually, and a lot of discussion. So I would encourage potential users of our legislation to have a look at those and just see if they're helpful, and if they are, and if they're not, and maybe you could send a note to Doug, and we can take that into consideration for future iterations of that of those flowcharts. Again, we think that our flowcharts, and we're aware that Nunavut Surface Rights Tribunal has a similar system, but we're the first jurisdictions of any application, I think, in Canada that's developed that kind of a system. And I think we really would be interested in feedback on that. Thanks. The other thing that in terms of costs, and we know that we are in an area that has no case law in the North. No one has ever set a cost for or a price for land in the hinterland. So it's a very difficult and contentious area, and we're quite aware of that, and we're trying to gain as much case law and background as we can. But our hinterland is exactly that. It's not land that has farms on it, and you're in dispute with someone who's drilling an oil well. We're really in an area of untried jurisprudence. So it's going to be interesting. It's going to be contentious, and I think we understand that, and we're working at trying to narrow down our focus to try and come to grips with that issue and surrounding issues. The other issue that we're very aware of is Section 35 of the Constitution Act, and this was one. This, of course, concerns consultation with Aboriginal people, and it's been an area of a lot of case law in the last 10 or 12 years, 20 years. And we now, because of the
Clyde
River decision, are arbitrators of that, of deciding whether an applicant has made good efforts and actually completed his consultation required by Section 35. So that's been passed down to boards with really none of us except our none of us on the board have any legal training. We do have a very good consultant, but you know, we're going to be making possibly some new law in that area, and we're aware of those heavy responsibilities too. So it's going to be very interesting when we get into actually doing and dealing with our first application. Thanks.
Yeah, thank you, Mike. Doug?
Just to reiterate a little bit of what Mike said. So we do have our easy to find website and the NWTSRB. Those flow charts are on there, our contact information's on there. We've had very little feedback outside our own organization on it. So if any of you happen to be navigating through there and you have any trouble doing so, we'd certainly welcome any feedback you might have.
Mike touches on something significant not only to the Surface Rights Board, but all boards in the Northwest Territories and likely across Canada. How this board attempts to fairly and properly apply Section 35 consultation in its processes is untried. Everything in this act is untried. And the fact that it extends into municipal lands adds another dimension which further complicates things. So as the legal community who helps to interpret and argue those interpretations of the law, I would say that this piece of legislation provides an avenue for creating clarity through the courts, if not through the decisions of this board. I'd really like to turn it over to the attendees to fire questions, and hopefully we can provide some substantive responses.
Thank you for that, Louie and Mike and Doug. Questions, anyone?
We love a deal, and bet you do too. Head to westjet.com/on-hold for tips on how to get the best value for your next trip and fly for less.
I'm not hearing anything.
No questions? Well, how many lawyers did you say were online?
I think there's about 15.
Or 15 counting you, Glenn.
Well, I'd ask the 15 people who are attending to ask yourself, should something arise with respect to an application and an individual is seeking counsel, are you prepared to provide that counsel?
That's a tough question to ask, Louie, because a lot of these folks work for institutions. So their clients are institutional.
Fair enough. Nonetheless, the matter still is before them, right? If someone's coming before this board and is seeking legal counsel, is our legal community prepared, for lack of a better word? And that's a rhetorical question, I suppose.
I think it's going to be, because I'm not sure you're going to get an answer. I did get a note on the in the chat that at least one attendee has got a number of other people with them, so that there's at least 18 of us and possibly more. If there are no questions, then what I'm going to suggest is that we close the session off. I want to thank Louie and Mike and Doug for their work. A reminder that we will have both of Louie's PowerPoint presentations, and we'll put them up when we get them. The audio of this presentation will be up on the YouTube channel probably sometime this afternoon. And if you were paying attention, you saw at the end of Louie's first presentation, the email address for Doug Rankin. So if you have questions, you can certainly send them to Doug. Oh, we do have a question. All right, here we go. And I'll give this to you, Louie, and others can chime in. What is the interplay, if any, between the land board established under the Mackenzie Valley Resource Management Act and the Surface Rights Board?
That's a very good question. In simple terms, I think the proper word is sort of plowing your own field. This board deals strictly with the rights and the disturbances caused on the surface by the subsurface landholder with an eye to those specific rights, and that's peaceful enjoyment. And the Land and Water Board operates under the MVRMA, and they're there to manage a different suite of public and private rights. And where our fields overlap, if you want to call it, is in the event that the board makes an order that must be interpreted by the Land and Water Board. The Land and Water Board holds final jurisdiction on that particular matter.
Thank you for that.
You're welcome.
Anything more? All right, and again, you can see on the screen Doug Rankin's email address if you have any questions. Again, thank you to Louie, thank you to Mike Vaydik, thank you to Doug Rankin for your presentation this afternoon. And with that, I'll close everything off. Thank you, everyone. Have a great afternoon.
Thank you.